I've I've sort of I'm still a lawyer technically, a solicitor, but I run a research unit at Leeds. Primarily, it's funded by a disabled children's charity, one based in Wales, Cerebra, which is an international research charity. So they fund our work. And I might quickly mention in a minute what we're doing. We're about to publish a big report. Maybe I'll mention that now before I forget. I used to work at the University of Cardiff, and so I've got an understanding of the social care law under the Social Services and Wellbeing Act. And with a colleague, Anne James, who lives in the North Wales, who used to work for Care Council for Wales, we run a website called Ridian Social Welfare Law in Wales. So that's a sort of port of call for technical detail about the legislation, because at the moment there are no textbooks on legal obligations in Wales in social care, because it's a small nation and publishing wise it doesn't really make sense. So that's why we have this website, and you can just go there, and it's sort of just free of charge, obviously. So yeah, at Leeds I run a research unit, and we look at problem solving for families, and we've just finished a report. It'd be very interesting. What we're going to call it is institutionalizing parent blame. How so it's focusing on parents of disabled children. I'll mention that I'll mention their rights, parent carers, under the Social Services and Wellbeing Act. But the charity does have an information resource, and we get a lot of contacts from parents who approach local authorities asking for help, saying, I want a parent carer needs assessment, and then end up feeling like they're being investigated for child abuse. They're treated as if they're parents who are neglectful. They're parents who are told that they need to go on a parenting course or something like that. So we've done a pretty hard-hitting report that will be published. BBC are going to run it towards the end, well, on the 30th of June, about the experiences of parents who are not treated as parents who need help, but they locate the problem of disability not in society, but in the family, and more particularly in mothers. It's pretty distressing situation. And although we looked at the situation in England, because there's a specific, it's much easier to research authorities in England than Wales because of the more abundant information about them that's available. We did get a lot of families contacting us in Wales who felt that they were being treated in the same humiliating way. They're asking for help, a social worker coming along and then insisting on seeing the child's bedroom, insisting on interviewing the child alone, all of which are quite severe interferences with private and family life when there's no evidence whatsoever of neglect. So anyway, look out for that. It'll be on my website and the Leeds website. So I'm going to rake through, as Jen says, I'm going to sort of walk through really basic stuff on carers' rights to social care and to a lesser degree healthcare in Wales. And after about half an hour, we'll then have some discussion, such if there are any questions or comments. When I'm presenting, which I'm going to do now, and put up a slide. These will be available as a handout. I can't see really the chat function, so if you put stuff in the chat function, I can look at that, or Jen can read it out to me or something like that at the end of my walkthrough. So this is stuff I imagine most of you are very familiar with, but it's just to set the scene. The definitions are very important legally, and the big thing that we see from the Care Act, the Social Services and Wellbeing Act, is that carers became very widely defined. So the Social Wellbeing Act says a carer is somebody of any age, a young carer or an adult carer, and all they have to do is to provide care for a disabled adult or child and not be paid for it. And that's enough. It used to be that they had to provide regular substantial care, but that's all gone. And the basic duties under the Act to carers are that the local authority must promote their well-being, and we'll have a quick look at what well-being means. And it's actually, I thought it was quite a weak obligation the courts wouldn't take very seriously, but they have. They've got a duty to assess the support needs of carers of any age, whether be they adult or young carers. And they've got to assess the extent to which carers are willing and able to provide care. And I'm going to come back to that because that's a core theme that runs through it about you don't have to do that in the UK. And that's true whether we're talking about health or social services. Carers don't have to provide care in the UK for family members. And if the carer then is assessed and their need is of sufficient severity to be eligible, then the local council must meet those needs, full stop. So I'm going to dwell on some of those things. And it's just a hugely important point that carers don't have to care in the UK. We abolished that on the 5th of July, 1948. The poor law was abolished by the National Assistance Act. And that was a great Anara and Bevan statute. And it's a great to go back and read Hansard about really the appalling indignities that disabled people, elderly people were exposed to by the poor law commissioners and their families. And there was a duty on families to provide care for family members. And only if that failed would the state step in. Now that's gone. In much of the world, it's still there, but in the UK, it's gone. So if you have a disabled, elderly or ill member of your household, the state has the additional responsibilities to look after that, not individuals. And that's incredibly important, because if it were otherwise, then we would have a system that discriminated against women. Because when we talk about carers, we are very often talking, particularly people who provide substantial care, women. And culturally, we have normalized that care is provided unpaid by women, and hence poverty is gendered and the rest. So abolishing a liable family rule is a very positive act of non-discrimination. Unfortunately, cultural norms persist for much longer than laws. So council mustn't assume carers are able or willing to provide care, and they must record on any assessment whether the carer is able and or willing to provide care. They must record on any assessment documentation that they've looked at the well-being list and the carers told them about which of those things on that list are particularly important to them, and we'll look through that list. And they've also got to record on the documentation what the carer wants to do with their time, their day-to-day lives, and how that may be seriously handicapped by their caring roles. And part of that will be whether the carer wants to work or stay in work or return to work, participate in education, training and recreation. And those are specifically things in the Act, primary legislation. All too often that seems to be just ignored in the cases that I'm involved in. It's just assumed that you've got a duty if you're a carer to do these things, and that's just not so. Now I'm going to, in this talk about a few ombudsman's cases, and the reason I talk about English ombudsman's cases is that again, it's much easier to get hold of them because the English ombudsman publishes all of their reports. And most of the ombudsmen now do publish all their reports. The only one that doesn't do that is the Welsh Public Services Ombudsman. And it's about time the Welsh Public Services Ombudsman did publish all of their reports, because otherwise they might make some incredibly important statements and none of us end up knowing about them. There are occasional ones that are published that they think are worth publishing, but the ones that I see, it's a very maverick selection. So I look to the English Ombudsman's reports because the English equivalent of the Social Services and Wellbeing Act, the CARE Act, that act and the Social Services and Wellbeing Act were really drafted from the same template. And in relation to carers' rights, particularly adult carers, there's really no difference between these two bits of legislation. So these English cases I'm going to refer to would read across into the Welsh context. So this is one of a number of cases the ombudsman's had to look at about a disabled person who has a Motability car. So that's purchased through their benefits, but the disabled person can't drive it. So it's there for the disabled person, but it has to be driven by somebody else, normally the family. And this disabled person had been assessed as needing to go to needing support during the day, which the decision was that was going to be met at a day centre. And the council said, and one of the support services disabled people need is transport to and from social care support arrangements. And the council said, well, he's got a Motability car, and therefore you've got to drive him to and from the day centre. And the ombudsman says the council had failed to consider the impact that would have on their health, the loss of respite care, because often respite care is to give, a day centre is to give the carers a break. But if they're driving somebody to and from the residential placement, the day centre, that just eats into their respite. But also there was no reason why they should do that. They didn't have to be ready, willing and able to do the driving. And they weren't. There's been, I say, a few cases on that. This is another report. And this is happening quite a lot in England, that local authorities are cutting packages. They're coming along, reviewing a care package, then reassessing it and saying, well, we don't think you need so much. But the inevitable result of that reduction is that actually their carers will have to take on additional caring roles. And as the Ombudsman has said again on a number of occasions, if a disabled person's care package is cut, and that will mean that the carers will have to take on additional responsibilities, then there must be explicit clarification in writing, almost signed by the carer, to say they're willing and able to take on that additional care. It can't be assumed that they'll take up the slack. Now, well-being is very widely defined in the Social Services and Wellbeing Act. And the well-being provision, the duty to promote well-being, is both for disabled people and for carers. It also applies to disabled children, and I've left that bit out at this stage. So well-being, and of that list, I think of particular importance is the first one, because the evidence suggests that at least half of all carers have a caring-related health condition. So caring is bad unless it's properly supported for your health and your mental health in particular. I think 56% of carers have a caring related health condition, normally acute stress, anxiety, depression, but other physical impairments as well. I think education, training, recreation is important. We'll look at a case on that. Carers have a right, just like everybody else, to take part in education, training, recreation, and because they don't have to provide the care. And participation in work is something I think that is also very important. A third of all carers give up work each year, and in a much larger proportion have to go part-time and so on. So those are things that must be specifically addressed when the local authority is assessing the impact of caring on well-being. So the way the assessment works, and you'll all be very familiar with this, is really you look at the carer and you say, what do you need? And very often what the carer needs is a break. They're saying, I am wanting to care, I'm willing to do that, I want to do that, but I need a break. I need to sleep at night, I need a night sitting service, or I need to be able to look forward to regular breaks so that I can just carry on doing this. So the assessment would identify a need, and that need would be a break. So on the carer's care plan, it would say the carer needs a break. The disabled person is then assessed for the additional support that they will need in order for the carer to have a break. And that might be a sitting service, it might be a night sitting service, it might be something of the kind. Maybe transport to and from the day centre, etc. And that additional support, which we often call respite care, is actually recorded on the disabled person's care plan because it's a service delivered to them. And that's how the two assessments should feed into each other. You can have freestanding carers assessments, but in reality, there needs to be the counterpoise, the backdrop of how that fits in with the disabled person's needs. Now, once the care has been assessed, there is then a process of deciding whether that need that they've identified is one that is sufficiently serious for the local authority to duty to provide support for it to crystallize. So there's lots of things we all need, but only some of them become legally enforceable duties on the state to meet. And there are regulations, so these are laws made by the Welsh Senedd to spell out how you decide whether a need becomes an eligible need. And they are mind-stonkingly complicated. The regulations in Wales are, in a number of respects, completely incomprehensible to me. And I may not be the brightest spark in the world, but if they are incomprehensible to me, then I think they will be to most people, including those who are assessing. I've got a few videos about the eligibility criteria in Wales on my website. So if you really want to do that, and it's not good for your mental health, go and have a look at those. You'll need to have a bottle of wine open whilst you do it, in my opinion. But put simply, the regulations are basically, when does the state have to provide support? And there are three hurdles that are effectively spelt out with the regulation. First of all, you can only get support if your need arises out of your physical or mental impairment or your caring role. So that's not complicated. I'm a carer. I need some support. The second hurdle is that you can't, because of your caring role, do certain things that are important. And there's a list of things in the eligibility criteria that are important. And one of them would be work. One of them would be going to college. One of them would be forming relationships, having a social life, being involved in the community. So, and for disabled people, I mean, they're the same list, but for disabled people, it would be activities of daily living like dressing, bathing, feeding, and so on, but also accessing the community and forming relationships. So because of my caring role, there's something on this list I can't do, and that's important. And I can't do it, that key task, unless the local authority provides support. So if I could do it with help from friends who are willing and able to do this, or from a local resource that is open and available and can do that perfectly well, then the local authority doesn't have to take responsibility. But if there is nothing out there that meets the needs, and in a way it's the duty of the local authority to point to those resources that they say meet the need, then the local authority's got to provide it. And we're in business. Then the duty has crystallized, it's got to be met. In reality, when I used to do sort of quite a lot of court work and litigation, we wouldn't lead on the law, we'd lead on the facts. We'd say to the judge, look, these are dreadful facts. This person is seeing her doctor with stress. This person hasn't been able to sleep. It's quite accepted. You know, you lead on the facts and you say, if the local authority doesn't provide help, this child is going to be at risk of being taken into care because the mother won't be able to cope, or this person is, you know, it just being on medication for anxiety, stress is enough, I think, to factually for the local authority to have to intervene if that's because of your caring role. So normally when you're arguing a case or when you're trying to get it, it's better to lead on facts and say, if the local authority doesn't provide support, these are things that could, indeed may well happen. And the greater the risk of those things actually happening, and the greater the severity of those things happening, the more compelling it is that the local authority would have to take action. So, yeah, generally, if one is arguing these points, it's just very good to put it graphically with evidence based of why this person will suffer significant harm, but it's harm to their well-being. And that would include, they might have to give up work, they'll have to give up college, or they can't go on a training course, or they can't go to the leisure centre or go on bird watching, you know, which is a vital part of their sort of activities for their mental health. The eligibility criteria break it down, but as I've already said, because you're a disabled person or a carer, you can't do certain tasks yourself, and there's nobody willing to help. And there are no community resources available to do that would readily be available. And this idea that you can't do it yourself is wider than that. So if it would cause you pain or anxiety or distress, or it would cause health and safety issues, or it would take you longer, you could say, yes, for a disabled person, yes, I could dress, but it would take me 3/4 of an hour, something like that. Then you can't do it. And the tasks we're talking about, particularly for disabled people, are eating, keeping clean, getting dressed, preparing meals, keeping the home clean. Keeping the home clean is quite a big issue for carers too. Involvement in work, leisure, learning, personal relationships, involvement in the community. And if you are caring for a child, then as well as the person for whom you're caring. That would be an additional issue. Once a local authority has decided you need something, and it's eligible, it's got to produce a care plan with the wicked detail, how, who, what, and when, basically. So how is that need going to be addressed? And it's very important, I think, for disabled people and carers to have a copy of their assessment to say this is what you need, and a copy of their care plan. And it's important for that care plan to be detailed. So instead of saying you'll need, the disabled person will need 9 hours respite care a week, it needs to also specify the skills required by the person or the organization giving that respite care. Many times carers are told, well, the local authority is prepared to meet the respite care, to look after the disabled person for periods, provide substitute replacement care. But the carer doesn't take it up because they're not satisfied that the carers that are visiting have got the appropriate skills, the appropriate attitude, the appropriate understanding. So care plans need to be very detailed, in my opinion. And you have a right to copies of the assessment, and at law to the care plan as well. I'm not sure if that happens, but it must. And if there's anything in the assessment that is factually wrong, and very often there are factual mistakes in care plans, that's the time to take them up. And the duty to meet needs is what we call non-resource dependent. So if it's decided that you need respite care, sometimes councils say, well, we only provide 16 hours or 16 days respite care a year, or some arbitrary figure. And the answer is, no, you can't do that. You've got to work out exactly how much respite care that person needs. And if that's 100 days, it's 100 days. There is no maximum care package that is available. Local authorities can have guideline policies, but they can't have fixed policies of that kind. This just gives another example of, it's a case I quite like, so you're going to be exposed to it. This is an adult with learning disabilities, and he lived with his parents. He was of a good age, and his parents were elderly. And his care package had for many years included 50 days of replacement care, respite care, to enable his parents to have a break. So what's that? A couple of days every fortnight. On review, this was reduced to 14 days. So massive reduction, although nothing had changed in terms of his needs. And the new assessment actually recorded that his parents were at risk because they were getting frailer. The care package was itself at risk, but nevertheless, the local authority decided to drastically reduce it, which is, in England at least, happening a lot. The ombudsman, and what the local authority said is that if there was an emergency or a problem, they would provide additional support. And the ombudsman held that to be unlawful. They had to provide an explanation as to why there had been a reduction. They need to show the circumstances that warranted that respite provision. Normally that would be because the disabled person's needs had reduced, but in this case, that wasn't so. And he said it was not acceptable for the council to state that it would offer emergency respite if the need arose. And this is the bit that I like. The parents' needs for weekends away and a little social life are not emergencies, but part of a planned, sustainable support regime. The council doesn't address these sustainability issues. The impact on the carers' daily lives of non-caring must be included. Now, I'm just going to rake through parent carers and then we'll take discussion. as I say, we're particularly interested because the charity that funds my chair in law at Leeds is a disabled children's charity. Our research is particularly focused on disabled children and their families. And so I'm going to just sort of cover this issue a lot because we're getting quite a lot of people being told in Wales that social services authorities don't do assessments of parent carers. They do whole family assessments. Well, that's just the local authority deciding it's not going to follow their legal duties, which is really not a course of action open to any of us, let alone a public body. So Section 24 of the Social Services and Wellbeing Act makes it the duty of local authorities to assess carers who are within the local authority's area, who what's called ordinary resident in the local authority area. And that assessment must consider whether the carer has a need for support and what those needs are. It's got to assess the extent to which care is willing and able to continue and to provide care. Now, sometimes local authorities say, well, parent carers don't have to be willing and able, it's their responsibility. But the ombudsman, as we'll see, and the courts don't agree with that. You can't force people to care. Caring isn't something that you can use language of that kind to do. Caring is something people do because they want to do that, and forcing them to do something they don't want to do or are unable to do. And normally with parent carers, what one's really saying is that I'm physically unable to do this, or I can't sustain the household and keep the house together and pay the rent unless I work. I'd love to have a private income, but I don't. So I'm not able to be with the children 24/7. And this is different to a parent for a non-disabled children because the disabled child requires so much more support. So the legislation says they have to assess the extent to which the carer is able to provide care, but also the extent to which they're willing to do that. And it's not in the English legislation, but it is in the Welsh legislation, and it's a really important and precious provision. It's an excellent provision in the Social Services and Wellbeing Act. And it says that a disabled child is presumed to need care in addition to or instead of the care supported by the child's family. Now that's a really brilliant provision, and as I say, it doesn't exist in England. So what the Welsh government, the Welsh Senedd is saying is that all care plans concerning disabled children, the default position is they must make additional supports for the child, because having a disabled child is an additional issue for families because of the way our society is constructed. So in a way, the onus is on a local authority to show why they don't think in their particular case there is a need to put in support, because the presumption is there will be a need for support. And this is a case that I refer to a lot, and some of you probably heard me say it before, but I think it's really one that a lot of local authorities should take into account. So this is a single mother with 2 children, one of whom had significant disabilities and needed constant supervision. The council told her that it expected parents to organise their responsibilities, work responsibilities around the needs of their children, that it wasn't its responsibility to provide support, in this case direct payments, just to enable a parent to work. And I hear that said over and over again. We're not a babysitting service. It's your kid, it's your responsibility. Don't expect us to provide support to enable you to work. Well, I don't know where they get that idea from, but they certainly don't get that idea from the law, because the law is explicit that well-being includes the right of parent of carers of any age to work. And everybody has to reorganize their arrangements in order to work. But if you have a disabled child, it's often incredibly difficult to make those arrangements because society is not geared up to provide after-school clubs or respite care for children with severe disabilities and need constant supervision, as hers did. But the council in this case said, but we are giving you, I think it was a break every fortnight. So if you don't use those breaks during the school term, you can store them up, those 2 days or whatever it is, and use them in a block during the holidays. So effectively what the council said is, we're not going to give you anything extra, but if you want to forego the breaks you have during the school term, you can then use them during the school holidays, which is really the local authority saying we're not going to do anything except be flexible. And the ombudsman said that this is unlawful. The council just didn't understand the law, and too often I think that's the point. They don't understand the law. Local authorities in England, and I think in Wales too, just don't spend time training frontline workers in what the law says. The child's assessment and the carer's assessment feed into each other. The council knew the son needed constant supervision. The council also knew the mother was in full-time work, and the nature of a job meant that she couldn't pursue flexible working. These were two factors, but neither the son's assessment nor the carer's assessment properly considered those issues. Government guidance clearly states that authorities should not assume a carer is happy to continue their caring. This is in England. In Wales, the Social Service and Wellbeing Act actually says that, the Act does. Councils are required to consider whether a carer wishes to work. Nothing in the assessments to suggest that the council properly considered the impact if she did not receive support during the school holidays. It's an important report. We do have a Welsh report, not dissimilar, but pre Social Service and Wellbeing Act. But the Social Service and Wellbeing Act added additional responsibilities towards carers. So this one would still apply today, but it would be an even stronger case. So this is a parent who was at university, and he wanted direct payments to enable him to buy respite care for his son so that he could pursue his studies. He wanted it to be flexible because obviously his seminars and lectures were at sort of varying times. The council said, first of all, that you had to give reasons why he wanted a direct payment, and that in any event, direct payments couldn't be paid for childcare, as childcare was the responsibility of parents, whether or not the children had a disability. Again, it's a council that just simply doesn't understand the law. These are things that are trotted out all the time. And you wonder where they're getting it from. And I think that is coming from, within the team or something, saying, well, we don't do that. And nobody in that team has been on a training course to be told that the law doesn't say that. It might have said that in 1948, but it's changed. And the ombudsman held that that was unlawful. That parents are not disadvantaged in pursuit of education training. Parents of disabled children are not disadvantaged in pursuit of education training any more than other parents. One of the problems we're getting at the moment is that local authorities are saying, we don't give you parent-carer needs assessment. We look at the whole family, and in that we will look at your carer's needs. Now, carers assessments and disabled people's assessments can be combined. For adults, they can only be combined if both the adult disabled person and the adult carer agree. Now, for children, the law is more complicated. And there is a situation where the carer's assessment and the disabled child's assessment could be combined, even though the parent carer didn't agree. I don't think there are many, but it could happen. But it's routinely happening, as far as I'm concerned, is that parent carers are not being given a separate assessment in Wales or England. And the point is this, that even if the local authority does combine the assessment, it's got to produce a separate document with the carer's name on it, telling them what their outcomes are, what their assessed needs are, and what's going to be done. So it's got to itemize their well-being criteria. The first point I made, which I sort of skipped over, is that councils can't have a fixed policy of doing this. They have a power to combine it, not a duty. But it seems to me that most local authorities in Wales are combining these assessments. And so we always combine them. Now that's what's called a fettering of a power, and it's unlawful. But even if they do combine the assessment, it must have a separate statement detailing the impact on the carer's well-being, what they want to happen as a result of the caring, what support they're entitled to, and whether they're willing and able to do that. And young carers, I just add there that the law is the same for young carers. They do have a right to separate assessments as well. The difference with young carers is that normally if a young carer has a need that's significantly impacting on them as a result of their caring role for another, for a sibling, say, or for an adult, then generally the idea is to stop young carers caring. It's not a question of sustaining young carers, it's just a question of stopping them carrying out inappropriate caring roles. Just to finish here, there on healthcare, there's very little legislation in Wales about carers' rights, as is exactly the same in England. The healthcare obligations, the obligation of local health boards to carers is very limited. At the moment with Carers Wales, we're putting with Carers UK, we're putting together an amendment to a bill going through the English Parliament to place a duty on the equivalent of local health boards to assess carers. And I think that amendment will go through. And if that happened, it might produce a duty to amend the equivalent Act in Wales, which is the NHS Wales Act. But at the moment, there's nothing in the NHS Wales Act that's specifically carer focused. The key issue, of course, is often hospital discharge, where there really is a need to involve carers. And as I've already said, the basic rule is the same in Wales. Carers do not have to provide care. They don't have to drop everything and care for a family member just because the hospital is screaming that they need the person out of their beds. Many family members don't like each other very much. Many family members are not very good at caring. And it's the responsibility of the state to provide in those situations, not to expect to just the family to just run around and accommodate the latest whim of the NHS, which has been closing beds at a stonking rate for the last 10 years, so that the bed crisis is increasing, forgetting COVID, because largely the NHS has been closing overnight beds for a very long time. There's a duty on the NHS and social services to work together to ensure safe discharge. And I think the point of departure in trying to understand that is an excellent Carers Wales fact sheet on the responsibilities of health and social services to involve carers in any of these decisions. So that's a very good starting point. Just to finish, resources. These are all on the internet if you need to get hold of them. At the bottom, you'll see that there's the Ridian social welfare law site that Anne, James, and I run. So that's the page if you go to it, and you can see there's a long list of links to detailed commentaries that she and I and others have written. The website is called the Ridian website because Anne's son, Ridian, tragically died over 5 years ago. He was a Bangor postdoctorate, brilliant but profoundly disabled person, and a campaigner, disability rights campaigner. So most of the stuff is there, new stuff that you see at the top. There's here, what's new, news is where we post developments on Wales. And with Cerebra, we've produced various guides on social care in both English and Welsh. In this case, this is one to do with young people. So thanks for listening. I've run through very quickly, but I still haven't gone quick enough. So I've only left a very little amount of time for discussion, but thank you. If there's any issues, questions?
Thank you so much, Luke. That was really, really brilliant overview in such a short space of time. And I'm so glad we've got this recorded. I've had a private message, a question from a parent carer. So, it was really interesting what you were saying about, you know, the right to work and you know, of course, but how one can be made to feel in those circumstances, and you know all of this, and you reflected that. And the question was about if a child requires care during the night and requires at least one parent to be awake during the night, for two parents to both have a job and take it in turn to stay up all night, that's incredibly difficult.
Yeah.
And so to be able to hold it down a job sustainably, does that require that, you know, they got a legal right then to get help overnight?
Yeah. I mean, if a child isn't sleeping at night and the parents are both in work and the Act says that they have a right to work, it's part of their right, and they don't have to provide care. And the Act also says that it is presumed that disabled children need more support than the family can provide, that it's presumed that care plans will have support for disabled children unless the circumstances, you know, don't warrant it. I don't see how you could argue that isn't something that would require a night sitting service. Perhaps not every day, but, you know, the presumption must be that it would. I mean, otherwise, no, I mean, it's just, you know, there's a sort of family life, you know, there's rights of husbands and wives to sort of sleep together effectively and have normal lives. And, you know, often there are other children in the household too who are going to suffer if there isn't that. So, yeah, I mean, I find it, I mean, there would be, that seems to me a compelling fact case. I'd be really interested to see how a local authority could say, but we don't need to do anything because there's two of you. There's a, you know, why aren't they allowed to sleep at night? Isn't that normal? And not sleeping at night isn't particularly good for you. There's a rather nice English ombudsman's case where the mother said, I need support because I want to take my child to school and to meet other parents. And she was blind. And so she needed somebody to accompany her. And the local authority said, well, no, that's not an eligible need, which it is. And anyway, your husband can do that. And the ombudsman said, you know, parenting is a shared occupation and she wants to do this. Just because she's disabled doesn't mean that she hasn't got a right to accompany her children to school. So, yeah, I would be very interested to see how a local authority would say, we don't think there's a need in this case.
Thank you. We've got two questions that have come in. One is how a carer can challenge a decision, coming from Marie, and Heather's got a question as well. So I don't know if Marie can go first and then Heather.
Yeah, challenging a decision. One of the things on there's quite a lot of resources on the Cerebra website. So if you Google Cerebra Public Services Toolkit, Cerebra Public Services Toolkit, you'll have, there's a, I mean, you've made a toolkit a bit like that, haven't you? And so Credia's got one that's got links to this, but that's about the generality of how you challenge decisions, and it's 36 pages long, and it's quite fun, and it's got template letters. So that's giving you an overview. So it's called the Cerebra Accessing Public Services Toolkit, and I think it's been downloaded 60,000 times, and we've got rid of thousands of copies as well. So that might be a good port of call, the Cerebra Accessing Public Services Toolkit. But also, if you Google Cerebra template letters, we've got on that website, we've got a sort of effectively a library, an electronic library that you can download letters. I wish to complain about the failure to provide an assessment. I wish to complain about the failure to answer my letter. I wish to complain about this. I'm seeking reasons why you're saying no. So that if you go to that website, you'll be able to just go through that list. And then if you click on the link, you'll get the template letter that you can download and then fill in all the missing, personalize it. So the toolkits are really, we call it the toolkit, but it's called Cerebra Accessing Public Services Toolkit. We've just put a new edition out, 2021, earlier this year. And it's fun. It's a nice document, a bit like your document, which is also beautifully illustrated.
Sally did the illustrations. Sally, next in the book, did the illustrations, inspired by your document, but also because Sally's a brilliant artist.
Yeah, well, it's beautiful. It's beautiful, and they're great, and so's the one we did, which was illustrated by my sister. So it's just lovely, so that's a good port of call, because it sort of has lots of tips about this is what you should say or shouldn't say, and this is how you should frame it. It's got template letters. And as I say, there is a really good library of template letters that we've developed for Cerebra. And the great thing is that some of them are just as good to use in England or Wales, but some of them are specifically in Welsh, not the language, but to do with the Welsh law, because of course the law is different in some respects. So if you Google Cerebra template letters, it will ask you if you want the English, Wales or Scottish version. Yeah.
Marie, just put your links into chat brilliantly.
Oh yeah, that's great.
It is a great resource. Thank you. Heather's got a question for you.
Thank you, Jen. Thank you, Luke, for your talk. It's been really great. I work for Community Catalysts in Powys, so I am enabling self-employed paid carers to set up their business. And obviously, I often speak to carers who are looking for care and support. And we've had a couple of occasions now recently where I've had a call from district nurses saying, could your people provide care to somebody who's at end of life, wants to come out of hospital? What matters to them is to die at home. And then it turns out that because they are not regulated by CIW. They work through an exemption to CIW registration. The answer is firmly no from the Health Board for CHC funding. And I wondered whether you have got any comments on that.
Yeah, but I don't think I can repeat them if we're recording. Yeah. If somebody is in end of life, then they are what's called fast-tracked on the continuing healthcare process, and they are the responsibility of the local health board. There's no doubt about that. They are the responsibility. So the local health board can't dodge that. If people want to die at home, which very many people do, and the guidance talks about sorting that out, end-of-life care is pretty one of the most important things that we can do, then the local health board have got a lot of options available. At the moment, we're sort of lobbying very heavily about things called independent user trust. They can pay somebody like a Centre for Independent Living to then provide, who can then commission that support. So in the toolkit, we talk about these issues. I mean, we list 9 commonly occurring problems, and one of them is the too difficult to think about box. Effectively, the public body is saying, we don't do that. But the answer is they don't do it because it's just difficult to think about. And they're going to have to solve that problem. You get this situation sometimes with a care home where somebody is very frail and elderly in a residential care home and they need to move to a nursing home. And it's technically unlawful to have somebody in a residential care home that everybody agrees should be in a nursing home. And so that's a breach of the CI's, the care count, the regulations for the inspectorate in Wales. And when you ask the inspectorate in Wales or the Care Quality Commission in England whether they would expect somebody to be moved to a nursing home, even though it would kill them, so as to satisfy the regulations, they say, well, don't be silly. You know, you don't sacrifice individuals to be the right side of regulations that clearly don't account for this. So, I mean, all I can say is that somebody needs to have a sort of fairly strategic conversation with the local health board. And that's where the difficulty lies, because I have yet to know how you do have strategic conversations with local health boards, to be honest. You know, clearly this is difficult and there must be a way of sorting it out. And just saying we don't do it is not acceptable if somebody's about to die. Mm-hmm. I don't know how you do it. I don't know how you get local, you know, I suppose it's going through assembly members perhaps, and very difficult.
Yeah.
There's clearly a solution if somebody bothered to think about it. So we put on our website, on the Iridian website, about a month ago, a longish paper about continuing healthcare and what's called independent user trusts, which is a way where the local health board can then pay somebody who could then pay somebody almost with a direct payment for which you wouldn't need to be registered to do that. And we did have an intelligent conversation with one member of the Welsh government a while ago, but he's now been moved to other offices. But we put down very strongly, this was a solution to these sort of problems.
Okay, thank you.
Yeah. I'd be very interested to know how you get on with that. Yeah, we'll
keep you posted.
Yeah, best of luck. Yeah. Okay, was there somebody else who had a question?
You're on mute, Jen.
Anybody else got a question?
I thought there was somebody else. Okay.
I've got one if you've got time to answer it.
Yeah.
So it's a little bit tricky and ambiguous in a way. But and you're probably finding this everywhere. But as with everywhere else, Powys is looking at the future of its day centres, and where I can completely understand, you know, the need for person-centred, bespoke day care. What we just happen to be hearing from a number of carers at the moment is that what's great about a day centre is that the person that they look after, like somebody with dementia, for example, is somewhere they can go every day. It's regular. It doesn't have to be organised and all the rest of it. And for that not to be in place, although they can get alternative arrangements, that it's just a bit more complicated because the day centre is provision for the
yeah. There's, I mean, I've written some stuff about this. There's a very nice court case on that. This is sort of sacrificing disabled people for dogma, basically putting dogma and saying, well, dogma says day centre is a bad idea, so we're going to get rid of it. It's also going to save them an awful lot of money. It's funny how dogma is always rolled out when there are financial savings to be made. And so day centres disappear, and in their place, often nothing happens because the alternatives are not suitable. And a lot of people, so there's a lovely case, it's Crown against Hertfordshire Primary Care Trust and Ealing Primary Care Trust, of a disabled person. He wasn't that old, but he had lived for about 20 years on a home farm trust. So this is somebody who was living in a residential placement, which was basically a farm. He had severe autism, and he was very challenging, but he really was calm by being amongst animals, which is not uncommon. And so he'd lived on this farm. Now, for the disabled people's movement, a lot of people thought these were sort of leper colonies where you isolated disabled people amongst able-bodied people. And it was getting and it was just like day centres got the same sort of stuff. The problem was that this guy actually liked it, and it was very good for him. And there's a lot of my clients actually like day centres. They may have become sort of habituated to it. Martha Nussbaum talks about this, but we've all become habituated to comfort zones. And suddenly the state says, well, you can't have that comfort zone anymore. You can't have a day centre because, you know, they're bad for you. Whereas in fact, and the judge is just a brilliant judgment as saying, you know, if you really do believe in personalised care, then you'll actually listen to what these people want. And it may be that this is an outmoded piece of care and a home farm trust, but it just happens to be what he wants. And if that's what he wants, then surely personalization would put him at the center of this and not your dogma of some assistant director who's been on a course that says these are bad news. And, you know, and the reality is that when day centers close, nothing really is replaced. I mean, I'm being very dogmatic about that, but I feel quite strongly about that. You know, have you taken a vote from the people in the day centre whether they want it to continue or not? No. And if you did, if they wanted to continue, why would you ignore it? You'd say, well, it's not good for them. Well, the Act says that, you know, disabled people are presumed to know their well-being better than anybody else. So,
and I suppose what perfect will be is not getting rid of services, but evolving and improving and creating from where you're at alongside people. So
yeah, you know, I mean, there are some truly dreadful day centres that, you know, and I 30, 40 years ago was suing appalling atrocities in day centres, but there are also some that people just like, you know. I mean, like going to the British Legion pub in the evening, isn't it? Or something like that. I don't think it's a very good thing to do. But then people do enjoy that, don't they? And why is it that that resource should be taken away? I'll send you the Hertfordshire case is a lovely case, where the judge really just says, you know, it may be that these sort of things are no longer fashionable or they're no longer considered appropriate, but this is a group of people for whom they work.
Yeah, yeah, really interesting.
Yeah, I'll send you that over. I think in my big book, which is now about English law, but I've got a section on day centre closures, which I'll try and dig out as well. Yeah, I'll send you the Hertfordshire case.
Thank you so much. You've been incredibly generous with your time.
It's lovely to talk to you. I wish I knew what you all thought, but I never will. I wish I knew what was really going on. I only hear from people that don't like what's going on, and it may be that everything's perfect. I'm just here from the disgruntled few. But you won't tell me.
I suppose you do, yeah. I suppose if you would gather things that are going wrong, there's an awful lot of exciting things that are going incredibly brilliantly, isn't it? I mean, I'm looking around the room and I'm just thinking of all of the incredible stuff that people are doing, and so maybe what would be a lovely way of you getting the access to all of that, Luke, so that you get that as well as the challenging stuff.
I'm so deeply prejudiced. You shouldn't sort of try and get me out of that rut. I think, yeah. But when I saw your guide, I thought it was wonderful. I love that, and yeah, I love Powys as a place, not necessarily as and Ceredigion and all the places where you live. So anyway, lovely to speak to you. Sorry, Matt, you've got a hand up. Sorry.
Hey, Luke. Sorry, I just wanted to ask your opinion on something, please. So our adult carers, some of them have been made aware of the MENCAP asylum. Have you know about MENCAP and the asylums, the abuse that's been happening?
Yeah.
So they've been talking, and at the moment we're looking at setting up a national authority to regulate this. Carers are terrified about what happens to the loved ones when they're not around anymore. So if they pass away, not compos mentis, or even just going to university or something. And they're really concerned because they rarely have good relationships with social services. They rarely have any good things to say about them. But I think we're under the impression that it is social services' job to make sure that the loved ones are still cared for after the carer passes away. You know, because and they're terrified that that's not good enough. And I just wondered if you knew if there was in Wales, if there was, who was meant to be responsible, apart from social services, who were meant to be responsible for making sure that they're cared for or still looked after. They want to die knowing that their loved ones are going to be safe. They're going to be happy. It's not just going to be good enough. It's not just going to be minimum standard. All of these great things that were put in place while they're alive and fought for and advocated for are still going to keep happening after they pass. And I just wondered if you know, is that just social services job, or is there an organisation that already exists that supports that?
No, I think it is just social services, and I think it's just so awful. They're the only group of people I've ever come across in my life who say they want their children to die before they do. You know, I was going to write so many have said that to me. You sort of think how awful an indictment of a state is that you have got into that situation. I mean, I'm doing some work a couple of weeks' time with an organisation called Kith and Kids in London, which was founded, I think, 60 years ago, and the people that founded it are still around because they're getting me to go and do a talk like this. And they set up all sorts of arrangements. They set up this brilliant, a bit like a home farm trust, basically. It's a community centre where their kids are. And their kids are now in their sort of 60s, I suppose. And the kith and kid members are slowly dying, but they're in their 80s. And the trust they set up is now just saying it's going to close. So you never lose this. You know, even if in your 80s and you have done all of these amazing things, you know that it won't last, because none of them really trust the state. If you've got money, you can do things. You can get the MENCAT wills and trusts unit. I mean, MENCAT does do that. So people with money into a house can, you know, set up a trust, a discretionary trust during their life and do that. But if you don't have those resources, and if you don't have, you know, family members who are, or friends who can be trustees, you have to rely on the state, and the state is not responsive.
Well, exactly like you said earlier, not all families get on, which is what one carer's told me. It's like their family's not going to look after their brother when I'm gone.
No.
So who does? And actually what you're saying as well, some of them, they have got another property they rent, and that money pays for their loved one, but there's still no guarantee that standards are going to be kept up, and who is responsible for keeping those standards up.
There really isn't much. I mean, MENCAT is about the only organization that does that. You could go to a private solicitor or something like that, but they would just extortionately expensive to do that. You'd have to be a millionaire sort of thing. So, you know, and this is something the state should do, and it wouldn't be very expensive. Often it's much cheaper than putting somebody in a treatment unit or something, you know. It's just, you know, this is what should happen in a functioning democracy. Sorry, I'm trying to be positive.
So if we did set up a regional authority, national regulation authority, shall I let you know about it?
Yeah, I think it's incredibly important. And, you know, when you say things like this, I think, God, we've got to do some research on this, except it's my research is about largely disabled children, but it is screaming out for, you know, and you just call it, you know, I hope my child dies before me. You know, I can never get over that idea of people just saying it and really meaning it, you know, and because they love their children so much.
Well, we've got some very active adult carers that are going to try and make this happen. So
yeah, well, there's some great people out there, but you do require the state to tango on that, you know, and they come out with this sort of nonsense about, well, that's a bit old-fashioned, we're going to move. You know, you can't rely on them just not changing something.
Yeah. May I ask if you have any advice on which organisations we should contact to maybe be involved with this? Obviously, Carers Trust Wales or Wales Forum. If there's anybody else you may have heard of, charities.
I mean, by all means, write on, you know, on our website, the Iridium website, we put lots of guest blogs up there.
Cool.
And it'd be really good to make contact if you did that. This is what we're thinking about. These are issues we'd like this, and because it is something I feel very, you know, it is such it's an issue that goes on and on and on. You know, Kith and Kids did this 60 years ago for exactly the same reason as it exists today, and it hasn't got better. So yeah, I'd encourage you to send us something, you know, something very short, saying we're thinking of doing this. It's a big issue, and Anne and I could just add, you know, we really believe that too. Yeah,
will do. Thank you very much, Luke. Cheers.
All the best.
We're quite hopeful about that, because the carers are shaping how Respite is starting to look like, and making it much more person-centred and relevant. And the council have really bought into that and are giving money towards it. And the same with awareness raising and co-producing that, so that it goes throughout. So this key issue that the carers have raised really recently, some of the carers that are really passionate about this issue have got really key positions now. On the regional partnership board, there's a really powerful carer steering group, And I just think in Powys there's more hope now than ever before. I think there's a real chance, and I think there's some, you know, in Ceredigion, I know most of the people here are from Powys, but in Ceredigion, you know, they got a whole carers unit. You know, the passion, the Wrexham Condemnation. I just feel I think the time is right. We got good people.
You don't mess with Mariona and Owen, of course.
That's where we should finish on a positive note. I mean, when I was at Cardiff, I knew Mark Drakeford. He was professor of social work at Cardiff, and he wrote a sublime book on this sort of issue. And, you know, in England, we have not had a Secretary of State for Health with any knowledge of social care or interest in social care since 1995. In Wales, your First Minister is expert on it. I'm not a fan of what they've done, to be honest. I really am not. But you know, I know he's right. His heart's in the right place. I don't know what the hell's happening around him, but you know, there must be there must be huge hope in Wales. As you know, Scotland's done some really great stuff. Scotland seems to have more courage, but yeah. So there's lots of hope. Powys, you're telling me, is wonderful, which I need quite a lot of convincing on. But if you tell me it is, I'll believe you.
Oh, there's a lot of learning to do, and there's a long way to go. But there's enough hope there. Do you know what I mean? There's enough. And there's just the right people in the right positions that want to do a good job, you know. I think if the carers are so brilliant at putting their point across, and they really got a seat around the table with the heads of services. They've got like young carers, you know, chairing meetings, and it is getting more powerful. But it's you know, a long way to go. But there's enough to go.
And carers are actually taking over the jobs in the council as well. We've got quite a few people who are actually young carers who are now participation officers and moving up and up and up. So slowly getting carers to work in the council.
I'm completely convinced. I'm utterly gullible, but I believe everything you say. So that's great. I've got to speak to somebody in 10 minutes. So that's fab. And we finish nicely on a positive. And
it's been so good to listen to. I feel like completely inspired by this conversation, and I know I've had some private messages in the discussion, and what you've said has hit home a lot. You know, it's meant a lot, more than I can do justice to. But for the sense that the carers can go away feeling more empowered in those discussions that they have that affect their lives so deeply, you know. I'm so glad we got this recorded. I think this is gold dust.
Now go and enjoy the sunshine and have a lovely day. Everybody, nice to meet you anyway. All the best. Bye.
Thank you so much.